Several issues, a restraining order, motion for adequate cause, and temporary restraining order, along with a temporary order, were all filed. I noticed service was affected on the 13th of July, and then there was an amended service for the 24th of July. Ms. Gronitz, there was no response from you in the file. What is your position?
I came to court Monday to put in a notice of appearance, went home to find out that my email had been spammed and it shut my computer down. And I've spent last week recalibrating. I am here with documents to submit, but I haven't had a chance to submit because I have 3 other court cases I got hit with at the exact same time. So I have filed a protection order against abusive litigation, which is what this is part of. Case number 23200764008. I haven't heard back from that. I left an abusive relationship. I found refuge. I was sought out by the law by my ex-husband, and now Jesse is jumping onto that lawsuit with this plan. So I intend to fight this in full. However, I am about 3 months behind their little litigation strategy game, and I am recalibrating as quickly as possible. So I am at the courthouse. I need to go to the copy machine, submit about 200 documents of previous CPS reports from 2016, about 6 to 7 different protection orders, and an entire decade of attempts by Jesse to remove my children from my care, always at inopportune moments when he should be helping me, and instead he's unhelping me. I left an abusive relationship. I'm living in my own house with my own money. He's claiming meth. I've never done meth, and he knows I'm anti-pharmaceutical because I won contempt of court in 2018, and he still owes me for that. I'm anti-stimulant, and he's claiming meth orders, even though I got drug tested on 6/21/2023 because my previous guy was trying to claim meth. So I haven't had a chance to get caught up, Your Honor. I'm counterfiling. I will take your advice on the best approach. Otherwise, I can submit my whole package tomorrow after I hit the copy machine today and go pay for 500 copies.
Ms. Rush?
Well, Your Honor, I mean, given that she's indicated that she's been able to file all these other actions I would submit in the last month, she should have been able to file a response to our petition. I mean, I don't know if you're on a review the record, but there's some really concerning issues going on here, which is why the court granted the ex parte restraining order. The declarations from third parties are not from my client, kind of corroborating her behavior and the concern about what's going on. I don't know anything about any protection order she's filed against my client. I know she has one against her right now with her last partner. My client, I mean, if we're going to set the hearing over, I would just ask that everything remains status quo and the restraining order just get continued. You know, we would prefer that the matter just move forward and adequate cause be found and our temporary parenting plan be found be entered because we did ask in our plan for her to be drug tested and have an evaluation. And so, I mean, that could move things along. If she's recently been drug tested, that would also be helpful to see, obviously. But you know that's the concern. The other concern is obviously, and we submitted this for the record, where she's living is not there's no water, there's no electric, there's no sewer, that kind of thing, and you know the kids are not safe in her care right now. And so I'll defer to Your Honor on whether you want to send it over or just move forward today.
Okay. So here's what I do. I'm going to extend the restraining order. So Ms. Rush, if you want to submit one like we did last time, so I'll extend that, keep that status quo. I'm going to give Ms. Gronitz until the 22nd. We'll set this over to August. Wait, do we have space on the 22nd, Madam Clerk?
Yes.
Okay, so we'll set this to 2 weeks to August 22nd. Ms. Gronitz, the only thing I can't give you any legal advice from the bench, but I will tell you everything that you file, you also need to make sure that you get a copy to Ms. Rush for her review as well.
Yes, Your Honor. Like I said, last week I had technical difficulties. I got here in time on Friday to submit the protection order. I was here yesterday for court. I attempted to do the summons and complaint for dissolvement of the committed intimate relationship, which is my way of securing the $200,000 that Nathan Jeff Bob owes me and is using legal measures to try to prevent payments. So I have secured protection for my children and myself. I am submitting paperwork to get repaid. And the funny thing is I left an abusive relationship and I'm on my own property that I own outright, zero mortgage. I don't have any debt. I have money in savings to fall back on. I'm working on that battle. That battle, unfortunately, is completely tied to this. Jesse has been helping Nathan cover his affair with another woman, trying to strip me of my house, my money that I'm owed for my contributions in my place for 5 years. And now he's attempting to strip me of my children. I accept the extension because I would like the chance to get caught up on paperwork because they've had 3 months ahead of me. I would like to request that Jesse be in charge of all of the children's school supplies and all of their uniforms and everything that they need to get ready for summer or for school this year. Because, well, quite frankly, I believe it's his responsibility as the parent who's taking care of them. Generally, I do that for them. I won't be doing that this year, and I would like him to. And I can be back at court on the 22nd. What was the time?
1:00 p.m.
1:00. Is that Zoom or in person?
It is Zoom.
Okay, because I thought today was Zoom. I was prepared at home, came to the courthouse after I looked at my paperwork and it said in court. I'm still new to this lawyering. I have a PhD in business management contracting. The COVID laws changed. I am working as diligently as I can. I have completely shut down my entire contracting business for summer to give this case 100% of my dedication. I let the thing with my ex. This has 100% of my dedication right now, Your Honor.
All right. Well, then I expect to have everything filed in a timely manner and we'll be able to proceed on the 22nd.
Thank you, ma'am.
All right. Thank you.
All right,
Mr. Fisher?
Yes. Is Michael Fisher present?
I didn't.
Interesting. He was here all the time and then he just stopped showing up. Okay. This is a motion to compel and discovery. I've reviewed that. There's been no response filed that I've seen.
I've not received any response. I've also not received any supplemental discovery or any of the items that he had identified in his discovery answers that he would be supplementing to me by email. So at this point, there has been minimal effort to comply with discovery, and he's clearly had an additional 3 weeks to produce documentation pursuant to this motion to compel, and I have received nothing.
All right. I am in receipt of your order regarding the motion to compel. I will authorize the $500 in attorney's fees and sign off on that order.
And just for the clerk's note, we have a review hearing scheduled for August 22nd. Is that still available at 1 p.m.?
I show it listed in Odyssey. Well, no, it's not listed in Odyssey. So, Ms. Cutter, is that date still available?
Yes, it is.
All right.
Thank you.
So we'll review this on 8/22 at 1 p.m.
All right, and I'll provide Mr. Fisher with a confirmed copy of the order.
Couch, and do we have Brian Couch present? Thank you very much.
Thanks.
Yes, Your Honor.
All right. Thank you very much. All right. We're here on a motion to sell the business. And in my review of the last hearing, it looked like Commissioner Carmi was unwilling to sign that without some indication from the trustee, essentially, and the issues surrounding that. I reviewed the, let's see, sorry, and yes, it was Commissioner Carmi. And I see the motion that was submitted, the subsequent motion that was submitted, and the correspondence from Joshua Daly, who is representing the trustees in this case. I have not received a response from Mr. Couch. Mr. Couch, do you have a response?
Yes, Your Honor. I think this is unwarranted. It's would actually displace myself, our two sons, my daughter's, our daughter's job, to have that done. And Ms. Ward is saying that this is a big emergency, have to, sell the property immediately because it's summertime, because it is in foreclosure. But that may be true for residential property, but this is also on a commercial property. So not only do I live here, and also my two sons, but it's commercial. It's not subject to, hurry up and get it sold in the summertime. There's a lot that has to be done to sell a commercial property. There's an environmental study they have to do on it. And what I'm saying is, you're not going to be able to just up and list it for sale and have it sold by November 3rd. It takes a long time. And it's not necessary, because I've already been in contact with a company that is actually going to bring in a tenant for here to, in other words, be able to make up the what's owed on the mortgage, to get it out of foreclosure, and then have the income to, make the payments, so it'll be solvent. And it's a fairly big property, so it already has a tenant on it who pays some, but it's not much, but it's the sole income right now. Okay, so I think by doing what the petitioner is asking is going to be very harmful to the family, and I don't know if she really appreciates that. Through negotiations, I am willing to, make payments to her, but she's refused and wants it all right now. But first of all, I need to get the mortgage caught up and then be able to start paying her. And I think that's reasonable. I think it's a lot better alternative to, displacing the family. And also our 12-year-old daughter, which I have visitation with, I don't have a place to go, Your Honor. So it's really going to be detrimental to the family. I would like it to be, I'd like to at least, have that chance to make it happen. And we're only talking a couple months. And also on this hearing, I wasn't even aware of this until Ms. Ward called me yesterday to work a negotiation. And then in that she said, oh, by the way, we have court tomorrow. I wasn't served papers for it. I'd like at least some time to look at the paperwork that she submitted. So it's been 24 hours since I was notified by phone about this.
Your Honor, if I may respond.
At minimum, I'd like some time to review that.
So I just want to point out that Mr. Couch was personally served with this motion initially on July 11th, 2023. He was personally served because it was being filed at the same time as a motion for contempt. We otherwise have an agreement for email service. At our last hearing, when the commissioner indicated that we needed some additional proof that the trustee was on board for the sale, we indicated that we would be refiling with that proof. That's what we did. Notice was provided via email. Again, we do have an agreement to that outside of anything that needs to be personally served. Mr. Couch did argue this motion on its merits when we were last before the court on July 11th, 2023. And he was previously personally served with it on July 4th. So he's known about this motion for over a month. He argued it on its merits on July 11th, 2023. Again, all that's been provided in addition is a letter from the trustee, which we indicated at the last hearing we would be obtaining. It is part of a motion in order to shorten time precisely because it is so pressing. I have not indicated that it's important to get it listed for sale because it's summertime. It's important to get it listed for sale because there is a trustee sale scheduled for less than 3 months from today. As the trustee indicated in their letter, if this property goes to foreclosure, what they're going to do is list it for the amount, just for the loan amount that is currently due, and that is likely to be the amount that it sells for. And that means there will be zero equity whatsoever available to anyone in this case. This is the only asset remaining in this case. Mr. Couch has sold all of the parties' personal property without my client's authorization and pocketed the proceeds. This is all she has left. He has refused to provide any sort of support pursuant to the court orders. And when we were left before the court on July 11th, a judgment was entered for $92,321.79. My client is never going to be able to collect on that amount absent trying to get some sort of money out of the sale of this property. If it is listed for sale immediately, which is something the trustee also supports, there is at least some possibility that my client might be able to get a little bit of equity out of this property to cover the judgment amount that's owed to her. It is owed to her pursuant to court order. Mr. Couch is correct. I have repeatedly tried to work this out of court. I scheduled 2 settlement conferences. I again tried to work things out with him on the phone. He stated himself, there is no way he can pay the amounts owed. So absent selling this property for more than the debt that is currently owed on it, there's going to be no opportunity for my client to collect the child support, the amount that is supposed to go toward the child's private education. And Mr. Couch talks a lot about the displacement of his family, but as stated in that letter from the trustees, this is not a residential property. It is not zoned residential. It is not permitted. It is not authorized by his clients that Mr. Couch is residing there. He's residing there with his adult children, and none of them should be residing there in the first place. It's my understanding that Mr. Couch lives in a trailer on that property. That trailer needs to be moved to a place that is zoned for having a trailer and for residential use. It's not appropriate for him to be living there. And as the trustee indicated, they also want Mr. Couch to vacate the property as soon as possible. And they support at least giving Ms. Couch an opportunity to try to sell it to a third party before the trustee sale on November 3rd.
Your Honor.
Yes.
It's untrue what Ms. Ward says about being able to reside here. This has had a farmhouse on here from its inception, and there's nothing in any of the documents that says that I cannot reside here. So that's untrue. And as far as trying to make a quick sale on the place before the foreclosure is just not realistic, Your Honor. But what is realistic is I'll be able to make up for the mortgage. I already agreed to secure anything that I would owe Ms. Couch after trial, secured by the property. So she can't lose on that. And then if it did come down to where I had to sell it, absolutely, would give us time to market it and actually sell it for market value, not a quick sale that Ms. Ward is saying is going to happen. Now, I've been through this before and was able to settle it, the mortgage, and I have all confidence we can do that again. And again, this is a family business. This isn't just me. And when she says, "Yeah, I can't have a trailer here," the other properties adjacent to it are all zoned the same, and they have trailers on them, RVs. So
I'm gonna stop you there. Here's part of my problem, Mr. Couch. This is obviously a big deal to you, yet you've done nothing.
Pardon?
This is probably a big deal to you. It sounds like it's a pretty big deal to you if you're thinking it's going to displace you, 2 children, your daughter's job, yet you filed nothing, you've done nothing. You show up today and you tell me all this great stuff, but I have no proof, no nothing. I have a notice from the trustee that says this property is commercial and not to be permitted as a residence. I don't have, so I'm talking now. I let you talk. Now I'm talking. So I'm assuming based on what you're telling me that this is obviously a big deal to you. I would think if it was a big deal to you, you would take some time out of your day and file some documents with the court so the court's able to make a proper decision based on everything before the court instead of just one side. Because everything you're telling me now, I have no proof of. You say, oh, there's somebody that's going to do this and become a tenant. I don't have any declarations regarding that. I don't have anything to show me that other than you saying that here and now. Great. I'm a little bit concerned overall because this letter does indicate that November 3rd is the date set for sale. So that's less than 3 months from today's date. So if there's a way for you to get that to go away, that's great, but I would like to have known about that now. Here's what I'm willing to do. I'm going to set this over 2 weeks to the 22nd. If you file proof that you have a way to get out of that trustee sale and you have a method to get payments back or started to Ms. Couch, and I'm sorry, Ms. Couch, you need to take payments if she's willing to take payments. You don't need to wait for one giant sum. So if you want to make payments, that's going to go towards what you owe her. So if she says, I'm not taking payments, I don't care. Go ahead and start making payments because that'll go to the ultimate amount that you owe her. And you need to file all the documentation. If I don't have that, I'm going to grant the request on the 22nd. That's where we're at. Okay.
And Your Honor, may I just add one thing? May I just,
Ms. Ward.
Thank you. I just also want to, I would like for him to also provide documentation verifying that the trustees are in agreement with any plan that he currently has. I know he's talking about some tenant coming onto the property to earn some income to get the property out of foreclosure. I just want to make sure that that's something that the trustees are aware of and that that is an authorized use so that we don't come back up against the same problem if it's discovered later that that's not in compliance.
I thank you for bringing that up. I think that is appropriate. So, I mean, you have to work, Mr. Couch, with the trustees. They've obviously gotten involved for a reason. And I have at this point, nothing that says otherwise that they're going to stay involved until this place is either sold or the plan that you hope happens. So we'll need some additional information from Mr. Daly regarding your plan, as well as whatever your proposal is. So you have 2 weeks to get all that filed. Make sure that Ms. Ward gets copies of everything that you're filing. And we'll revisit this on the 22nd.
That's correct. So there's two issues.
Honor.
One is a presentation of an order from May. Ms. Gilmore did file just a single objection that should be in your file. The second issue that it's on the docket for today, I don't believe is accurately on for today, and that's review of the GAL order. It's GAL report. It's my understanding that the court previously set that over to review on August 29th. Ms. Gilmore wasn't involved when that happened. She said, sort of find me the document and I'll agree. I just haven't had time to do that. We do have the GAL with us today, and she can confirm if she recollects. The court had set, the reason why is that the court had set the restraining order review to the 29th as well. The child's doing 8 specialty sessions with a counselor that specializes in abuse of young children. And so the idea was that the guardian ad litem would have time to review those records and then issue her report. So that was my understanding on that issue.
And so do you want to hear from me? Sorry.
Yes, go ahead. Sorry,
Sorry, I kind of jumped in. My understanding is the opposite. And I can kind of give the court some timeline or the timeline to refresh. So the immediate restraining order was entered in on June 2nd, based on a disclosure from June. And the court entered the restraining order with the understanding the child or the children would be interviewed by CJAC. That interview was completed on June 23rd. We were then before the court in another June hearing, I believe it was June 27th, where father made a second allegation of a disclosure by the child. The child, as we provided under seal, was subsequently interviewed for a second time on July 25th. We filed those records showing that the child made no disclosures from the second allegation. So at this point, my client hasn't had any visitation since May. We're on procedurally before an immediate restraining order. And as the court's very aware, an immediate restraining order is supposed to be immediate. So we're supposed to be before the court within 14 days if the court finds good cause. But I'm concerned that we just simply, my client's not having visitation. She historically was the primary parent. I know that, again, I wasn't part of some of this argument, but my client has the right to at least progress forward with at least supervised visitation at this point. We are frustrated by the fact that The court reappointed Ms. Ravina in May. My clients had zero communication with the guardian ad litem as we filed under pursuant to the court, and we just don't want to kick the can anymore. These children have the right to have a relationship with their mother. My client has a right to parent these children. And so I'm concerned that we just continue this on until the 29th, and we're just having another set over because Ms. Ravina hasn't investigated the case at this point because she's had no communication with us. So I asked the court to review it. I asked the court to reestablish visitation pursuant to the parents who plan entered in December. I think that all of the CJAC issues have been resolved. And so I think that we need to progress forward. And I think that we can talk about the order, but I think that the order itself that's proposed indicates that the review is supposed to be set today. So I'm confused. I don't see anywhere where there's an indication that this matter needs to be set over. So I do think that we need to move forward. I don't want to be entering into September where we're having another set over on a GAL review.
And so briefly, that's just incorrect. If you look at the court's order of July 11th of 2023, the court specifically set the review of the restraining order to the 29th of August. The court can review that court hearing where we discussed the fact that the child was in specialty counseling that was specifically, the specialty is young children who've been in abuse situations, and that was the information the guardian ad litem wanted to review. And I believe we also even discussed the timelines of when that counseling was happening, when it should be completed, and that's where we set the review to the 29th. So it's not really fair to say, well, GAL hasn't investigated the counseling records that are being created right now. She can't review things that don't exist. I would absolutely object to the idea that we're going to do something that's not before the court at all today, which is to change the restraining order, which isn't set for 3 more weeks. That's just not appropriate and not at all what we're here for. We're here for a presentation. At most, we're here to review a GAL report. And again, not fair to the GAL to say, where's your report when we already said we were going to look at it after she's had access to those records.
So as to the restraining order, I do see in July 11th, Commissioner Carmi was on the docket. She made a good cause finding to extend the restraining order through 8/29/23 at 1 p.m., finding specifically that the child needed some level of protection given the CJAC interview and the counseling that was, I don't know if it was ordered or requested, but between the CJAC and the counseling. So there was a good cause finding to extend the restraining order through 8/29. I have us on today for entry of the May 30 order and a GAL review. So based on, and not hearing that case and just reviewing the notes from Commissioner Carmi and the minutes, it appears as though she addressed the extension of that restraining order and made a good cause finding based on the minutes and notes that I have here. So that'll stay for the 29th. I just note the concern. I understand the concern, Ms. Gilmore. And the objection, going back to the hearing order on May 30th, the objection was to page 2, line, or paragraph 2, first line. Is that correct about the AT&T records?
Yes.
Yeah, just as to sort of the court's finding on that they were very different than what Mrs. had submitted versus what the subpoena provided.
So I'm going to leave it, but I'm going to strike through significant, so that there were discrepancies basically, and I will sign that order. And then I did see, Ms. Gilmore, the filing from the correspondence attempted with Ms. Ravina. I don't know if she's present today. I don't know what's happening there. Clearly the court doesn't have any reports. I don't know if the council has received anything.
I received no communication back in response. I can update the court that she did call my client, I believe, yesterday. I tried to call back, but then I was in a consult. I just think at this point it's a little too late. And so my client's trying to progress this forward to have a successful hearing on the 29th to move forward with visitation. And we're not having participation by the guardian ad litem. So,
and she is president. The guardian ad litem is president.
Can you hear me, Your Honor?
I can.
This is Tanea Gravina, guardian ad litem. I did receive, or I was appointed to further gather the information from CJAC, from CPS, and from the counseling. The sessions were, from my recollection, to go to the 18th, not the 8th. I was surprised to see that we were on the docket for this today as well. My understanding was that we were reviewing this at the end of the month. I have I did call Miss Gibson over the weekend. And really the only response, once I was reappointed, I had sent an email to all the parties saying these are the costs and requirements to move forward. I received a pretty short, please let me know what you need, but had outlined everything I needed to proceed forward. I have not received any payment. I have received a please update me again email from mother. I did call her. I have reached out to father. I received text message communication back from him, but no call back from him. But again, no payment since the initial part of this case, and have put forward 3 reports. It is not as if I have just blown off and not continued investigating. This has been a very intense matter that has gone on extensively and has impacted other cases, which I had to catch up on in the meantime as well. And so, as my understanding was that I was to gather additional information regarding the sessions and the findings with the children, that is what I am still working on. I have just not received that information back from CPS nor from the therapist yet.
All right, Ms. Baldwin, Ms. Gilmore, any concerns with your clients being able to make payments to Ms. Gravina by the end of the week?
No, I'm dictating to my staff right now that happened right now. And the materials, my understanding is the child met with the specialty counselor. Essentially, I think she began the end of June, beginning of July with 8 sessions. So that timeline fits with the guardian ad litems. I know it can just take time to get documents from them. But again, we'll work with Ms. Gravina to try to facilitate her getting access to those the documentation as soon as possible to help her finish her report.
And I'm just, sorry.
No, go ahead. I was just going to ask Ms. Gilmore your position.
I was just reviewing the email correspondence. My client is, as indicated with the new communications, more than willing. She was just asking a way to set up a payment plan. Based on that request for a payment plan, I don't know if she can pay in full, but she's more than willing to pay some sort of amount to ensure this moving forward. And I do request, if this was an issue and Ms. Baldwin had indicated to potentially an objection, but I have requested the GAL file both through my client and through myself. And I think that the order itself, as well as the GAL rules, require her to supply that file to me. I'm not trying to cause any further delay, but my client has the right to those materials. So if you can provide direction on if that is actually required by the court.
And my understanding is that they're required to do that after the report is complete, because otherwise what you get into is these he said, she said, he said, she said, with both sides then demanding the file constantly. And so that it's available once her report is complete, and that they have to pay for her time to get it. So, and not that can be excessive, but the copying costs and those types of things. And so that's my understanding of the court's rule. But again, the court can rule as it likes on that.
So, and I guess if I can pick your brains, does the entire case being complete, or in this case we have Ms. Gravina indicating three separate reports already filed. Could one ask for the records on all the stuff that's already been completed, or do you think the entire file, that it's once everything is done?
I think it's once she's essentially completed her investigation. What's been hard is she's issued like a interim report, and then the court's kind of said, well, now go and investigate X and Y. I think you're asking her to do a lot of work to then separate out what came before and what came after, kind of a thing.
I think that, frankly, I've never been aware that anything needs to be finalized. I don't think that the order states that whatsoever. It says that basically we're open to request the file. I don't think there's anywhere that says that the case must be complete. And frankly, since we have open litigation and we're concerned about she's filing declarations, basically supporting concerns. And so my client has a right to respond and be provided notice of the materials that she's basing this on. And so I think that, and I'm concerned by the fact that she's either refusing to or ignoring the requests, which makes me even more concerned and want that even further. So I do think that my client has the right to those materials and should be provided them timely.
All right.
And Your Honor, I'm sorry.
I have some concerns that, and I know the GALs have heard this from me before. If payment is an issue, it needs to be brought before the court, not at the last minute. This is inappropriate to delay for payment. There was an attempt to contact for payment. Sounds like Ms. Gibson said, how can I set up payment plan? I read the emails. There was zero response. And that was in end of May, beginning of June. And here we are 2 months later, excuse me. And nobody's paid me. And we've been in court I don't even know, probably half a dozen times in that 2 months. So I'm a little frustrated by that. Payments, it sounds like, will be made by the end of the week. Ms. Gravina, do you think that you can have a report for the 29th of this month?
My understanding is the counseling is complete, I believe, on the 18th. So long as I get documents pretty immediately after that, that was my intention. My understanding was that my scope was pretty limited for this additional appointment. I did just briefly meet with Tina before she leaves on vacation to ask her about the specifics about providing my file and things like that. And she said that that is not done until the case is all over with. So I did seek advice of Tina for that, just to find out where that was at, because I have completed reports already in this matter. She indicated I should wait. But as far as receiving the records, as soon as I get those, I can kind of, compile that limited amount that I'm looking for and provide that to the court to the best of my ability. I imagine it will be within a week or so, as soon as I get that.
All right, well, let's shoot for the 29th. And then I'm going to authorize Ms. Gravina to release her entire report as soon as this last report is completed. So that won't be, hopefully, an unnecessary delay. We understand it may not be the 29th of August, but my hope would be that it would be very soon thereafter. That would provide Ms. Gibson an opportunity to respond and move forward from there. So we'll set the GAL review over to the 29th of August in the hopes that we have some information there, and then review the restraining order on the 29th as well.
Thank you.
And I've signed that other May 30th order.
Judge.
Very good.
All right, thank you. We are here to look at the refinance or sale of the home.
And best of my understanding, I did speak with my client very briefly the other day. It appears to us that home is going to be listed for sale. Understand that the refinance efforts of Ms. Tiemanson were, I don't know if she did not qualify or she just agreed to sell the home. That part is somewhat ambiguous to me, but nonetheless, I think given the context of the existing divorce order from last year, it's pretty clear on its face what's to happen. I've not been provided any documentation or updated information in some time from Ms. Tiemanson, but again, based on what my client informs, within the past 48 hours or so, it was his understanding that Ms. Tiemanson plans on listing the home for sale.
All right, is Ms. Tiemanson here?
Yeah, can you hear me, Your Honor?
I can, yes.
Okay, perfect. I'm sorry, I've been having difficulties with my computer and I wasn't sure if I could be seen or heard. I apologize.
I can't see you, but I can hear you. So.
Okay, perfect. Yes,
right.
Mr. Zandy is correct. And I didn't qualify for the refinance.
All right. And is there a plan? Are you working with Mr. Zandy or Mr. Tiemanson with getting that listed, or are you spearheading that yourself?
I didn't know what I was really supposed to do or how that worked. Either way works. I can do it, or I can work with Mr. Tiemanson or what they say. I just wasn't sure how to approach it. And I've been trying to keep Mr. Tiemanson updated on the information of the home.
Okay.
My suggestion, Judge, is that
sorry, go ahead, Mr.
I apologize. My suggestion is just that I craft an order and we can set this for 3 weeks out, and I'll get that to Ms. Tiemanson by the end of the week. Ma'am, what I tend to include is just information that's kind of standard. Here's the agent or an agreed agent between the parties. Any material disputes are resolved by that person. And then we can just kind of make sure that it's being tracked and listed accordingly and go from there. It might streamline things, make it a little bit easier, so everybody's on the same page with that.
Does that work for you, Ms. Tiemanson?
Yes.
Okay. Do you want to set a presentation date for that, or do you feel that you can enter that ex parte?
I think we can probably do it ex parte, but just for tracking purposes, if we had a hearing at the first part of September for presentation, that would be ideal. In the meantime, Ms. Tiemanson, if you want to get me your preferred listing agent, I would certainly talk to Nick about that.
Perfect. Yes.
And include that. I think where we sit right now, we're not overly concerned with who lists it, just as long as we get out in front of that and do it soon.
Right. Okay.
All right. So let's, let me here. Looking at my calendar, how about we set a review for September 12th? at 1 p.m. And then that can be struck if there's an agreed order entered by the parties.
September. Oh, sorry.
Hold on, Ms. Stevenson. Mr. Zandy, what was that?
No, I was just going to say, I think there's a pretty good likelihood that we will reach an agreed order on that once I get whomever it is Ms. Stevenson prefers to list up.
Yes.
All right.
And I'm sorry, I was just going to say September 12th.
September 12th at 1 p.m.
1 p.m. Perfect.
If you and Mr. Zandy agree on the order, then we'll just strike that court date and you won't need to be here.
Okay, perfect. Thank you so much.
All right. Thank you, Ms. Stevenson.
Thank you.
Thank you.
And
we have Mr. Dombrowski earlier.
I'm here, Your Honor.
Okay, thank you. So we're here for a motion to waive MSC and then an objection to that waiver. Go ahead, Ms. McLean.
Thank you very much, Your Honor. So as you can see from the documentation, my client, Kelly Dombrowski, is asking the court to waive the mandatory settlement conference requirements. My client is a victim of harassment and threats by Mr. Dombrowski. Protection orders have been entered previously on behalf of these parties. From my client's perspective, and quite frankly, mine as well, Mr. Dombrowski seems to be invested in conflict. We've had conflict within this case. We've had conflict within the administrative child support arena. There have been oodles of money that have been spent in or earned in regards to attorney's fees in this case because of the ongoing conflict. And my client is simply trying to conserve her resources for purposes of trial and finalizing this matter. We did forward and exchange settlement negotiations. We were not successful in that. In my opinion, given Mr. Dombrowski's response, I don't think that we're going to get anywhere close to resolving amongst ourselves. And to be quite honest, I don't see a court commissioner being successful at a mandatory settlement conference, given Mr. Dombrowski's position at the time of the administrative hearing relative to child support. So our position is that given the history of this case, the substantial conflict that's involved in this case, the fact that Mr. Dombrowski at this juncture, a year out, has not complied with the court's order to participate in a domestic violence evaluation with collateral input, we think that the court should waive mandatory settlement conference and allow us to note this matter for trial assignment.
All right, thank you. Mr. Dombrowski, do you wish to state anything other than what was outlined in your motion to objecting to that?
Yes, Your Honor. I have not harassed her client. There's been several allegations that I drove by her place, which is untrue, unfounded. There's no history of abuse, domestic, mental, any abuse. The court did order a restraining order. I understand that is usually normal from the beginning. I didn't violate that order. They did not renew that order. As far as the GL investigation goes, Ms. Gravina in September of 22 stated for me to redo my drug and alcohol evaluation, redo my mental health assessment and anger management assessment, which I had already completed, but Judge Hahn did not order it to be collaborative. So when September, she wanted it to be collaborative, and because she said there was so many alarming allegations. Well, in October of 18, we're in the middle of court. She calls me after court. I called her back, and she said she knows nothing and continued to say, I'm an advocate for both parties. She continued to, and I informed her of what she said in September, that she had read through the whole case file. And she was dumbfounded. And Kelly had made some comments to our adult children that she would make it really hard for me to see Zach. And I don't have the time or money to deal with this. If she doesn't want me to see him, fine. You deal with it. As far as the child support and all that goes, she's paying $20 an hour for daycare and for one-on-one daycare, which I don't believe that Zach needs one-on-one daycare. He's been in public daycares before. At $20 an hour, it comes up to $4,400 a month through the summer, which equivalates out to almost $2,000 a month, plus my $1,000 a month child support. So at this, my last payday, I got paid $400. I can't survive on that type of judgment. I called my caseworker through the support services through Washington State Support, and I do understand that it's important to get this divorce finalized, but I do not believe that one proposal from Miss McLean to me and my counter proposal is reason to believe that we can't reach an agreement. She wants half of my 401k, but she doesn't want to give me half of hers. Miss McLean inflated my assets and inflated her debts to make our incomes look equal, in which they're not. My income has severely been reduced since COVID's ended, and I don't work a lot of overtime. And so right now I am getting behind in child support.
Okay. So I appreciate your position, Mr. Dombrowski, but we're, the only thing that's before me today is the waiver of the mandatory settlement conference. And I understand that you're opposed to that, and you're opposed to that because of the allegation. So there's a, court can find good cause to waive a mandatory settlement conference if there is several things that are alleged. One of those is allegation of domestic violence. So you're objecting based on those grounds. Is that correct?
That's correct.
Okay. And I haven't had this case the entire lifespan of this case. What I did note, however, is that in the initial orders, and I should have earmarked those, there was a temporary restraining order, which is different from temporary orders. There was also, so that restraining order, there was good cause found for that by another judicial officer. Additionally, in the initial parenting plan, 191 factors were found specifically that alleged domestic violence, again, by a different judicial officer. Because of those allegations and the representation of the continued concerns there, I am going to grant the waiver of MSC, and this will proceed straight to trial.
Your Honor, can I say something?
Sure.
So just because they allege that I participated in domestic violence, there's never been 30 years, not one 911 call, not one sheriff coming to our house, not one time has she ever been to the hospital. So my attorney argued this last time, and in 30 years, there was nothing. So how all of a sudden can she come out and say she's doing this to harm me? And
I'm not gonna go there with you, Mr. Dombrowski. I understand the concern. I completely understand your position. I didn't make the finding, but I don't have anything before me saying I should reconsider that finding. So the finding was made by another judicial officer, and because I don't have any information to tell me otherwise, I'm kind of forced to stick with that finding. And that's why I'm waiving the settlement conference. So I don't know, Ms. McLean, is discovery complete in this case, or is this going to be noted up for trial assignment soon?
It will be noted up for trial assignment soon.
All right.
Thank you.
How soon?
We're not gonna
Your Honor, how soon?
You can have that conversation with Ms. McLean off the docket, Mr. Dombrowski.
Thank
but
you.
hopefully soon. All right. Good luck.
Good afternoon, Your Honor.
Good afternoon. And I saw Ms. Amaskita here. Okay, so I'm really confused about what's going on here, because I see this case has been in front of Judge Evans several times since we were last here for temporary orders, when I thought I had entered some pretty explicit directions thus far. So that's my first question. Second question is it appears Ms. Amaskita has done everything that was requested of her, and there's been nothing filed by Mr. Miller. So Ms. Holder, if you want to answer those questions for me, I'd greatly appreciate it.
Yes, Your Honor. We were in front of Judge Evans for a modification of the parenting plan regarding child custody payments or child support payments, as there has been no payments from Ms. Amaskita, despite the fact that Mr. Miller has had full custody of the child since October. So that was what that was in regards to. There has been no child support between the parties at all for the entire pendency of this case. So that was why that was done.
All right. why is there nothing filed on Mr. Miller's behalf for domestic violence evaluation?
That is my fault, Your Honor. I do have Mr. Miller's assessments, and I've actually just signed the submissions right now, and my paralegal is submitting those to the court as we speak. So that is my my error. I have not seen Miss Amosquita's, what she has filed. She sent things to me that was just a cover sheet. So I was not aware that Miss Amosquita had filed with the court. And it was my understanding, based on what Miss Amosquita had said in the motion for temporary family law order modification, that no one had filed anything as they were waiting for all the parties to exchange before they decided to file. And they weren't going to file anything until they had seen Mr. Miller's. And we had just finished that, and it was signed off on July 24th.
And I have that she filed her domestic violence evaluation July 5th.
Okay. My apologies again. I did not see that.
Index 35. I don't know if Miss Amosquita, did you serve?
Yes, I emailed everything to his attorney. Mine got done, and then the lady said she had to wait to complete Mike's, and because of Michael's, and all that debt was done on July 20th.
So Mr. Chaddock's was done on the 20th?
Yes, and I filed his with all the child support stuff.
Yes, Your Honor, and Ms. Amosquita is correct. That was also filed because Mr. Chaddock attempted to have the DDPO dropped, and it was also filed in that case. And that is how I saw his DD assessment.
Okay, so Ms. Amosquita, have you been able to have your visitations?
I have. This last week, I haven't seen my son because I had COVID.
Oh, I'm sorry to hear that. I hope you're okay.
It's been hard for me to get a hold of Michael because he wasn't paying for the app because he couldn't afford to pay it for this month. So I've been trying to talk to his mom about visits and calls. And I did let her know that I had COVID and I should be fine to see him sometime this week.
Okay. But other than your illness and the app not being reliable, you've been able to have your visitations all summer?
Yes.
Okay. Ultimately, I mean, I would like to see Mr. Miller's evaluation. Ms. Holder, you're in a unique position where there may be a opportunity for you to negotiate some potential resolution here. For his stuff to get filed and to set a review out, if we keep everything status quo, do you think 2 or 3 weeks would be ideal to review this?
Your Honor, we can do it in 2 weeks. That would be appropriate.
Okay. So if you're filing those this week, I'll look for those so I can come up with something. My hope would be, assuming that I get everything timely filed, I'll have a parenting plan drawn up for the 22nd. So Ms. Amosquita, I hope you are feeling well soon and you can get your visitation started back up, and then we will come back on the 22nd of August at 1:00 p.m. And I'm going to say it's for review. My hope is that we'll be able to enter a final parenting plan at that point. All right.
Thank you, Your Honor.
All right. Thank you.
Matter's ready, Your Honor.
Okay. Thank you.
All right. I have relocation and taxes are on the list of items to discuss today. And I did receive materials from both parties, and I see everyone present. So, Mr. Zandi, I will start with you.
And I would submit, Judge, that I understand Mr. Hitchcock did submit some materials, but after that, it's my understanding he notified my office and said, well, some of them didn't come through, but you've already got it. It's stuff that's been included in the past. And then most recently, we were served, I want to say last night or this morning, looks like a request for a continuance that he addressed it to Your Honor. I'm requesting a continuance for this motion to get a lawyer. Regardless, I don't think any of that is properly before the court, but this is an issue that needs to be heard today. We're asking to move forward, and I'll let the court kind of decipher what is appropriate and what's not. I just want to raise that objection to anything that I was not served with, whatever that is. We ask the court not to consider that.
Okay, let me see. So,
do you want an explanation at all for that?
Yeah, I want to turn to you, Mr. Hitchcock. The last thing that I show in my file is looks like I do have the motion to continue that you filed, well, yesterday afternoon. Is that correct?
Yeah, and then you have something I filed last week as well.
I have the filing from August 3rd, the opposition to relocation.
Yep.
Is there anything else that you filed that should be there?
No, no, not at all. And my scanner did, it actually like totally went kaput, and you can actually see it on the scan to Mr. Zandy. But I did forwarded him all the information that I put in that was at the end, minus the notes. And I said that in the email, and that's actually what it says is the only thing this ends with is the notes that you guys have access to. And then I sent the email of the things that weren't the notes that they did not have access to.
The visitation notes?
Yes, they have access to the visitation notes.
So the text messaging and voicemail and looks like an email that was supplied via email later. Okay. Okay, so it looks like that was, I have 43 pages in its entirety, Mr. Zandy, that was filed with the court back on the 3rd of August. I did not, looks like the motion to continue was filed yesterday afternoon. It landed in Odyssey this morning, so I see it's here. I just haven't reviewed it. It's just, let me review that real quick here.
And I don't know that we got a motion per se, Judge. What I have is just it looks like a typed out letter from Mr. Hitchcock asking for said continuance. I don't see the motion, but regardless, I think it puts us in the same spot. I don't want to get too lost in the weeds with that, just as long as everybody's on the same page.
Yeah, it just has a cover page on it regarding the motion to relocate.
Okay.
You're objecting to the continuance. You want to move forward today, Mr. Zandy and Mr. Hitchcock. Have you contacted any attorneys or tried to contact any attorneys at this point?
I contacted one since they filed this. They haven't called me back. I need to contact them again. And I mean, once again, I mean, this was filed on the 18th for, to move within a month. So I don't feel like that's the right thing to do for my kids. Or, I mean, I also don't believe it's legal based upon the laws. And
if I were to grant a continuance, how much time do you think you would need to be able to be present with an attorney to have the court hear this case?
Well, and it would take like a month, I would think, to get an attorney. Attorneys are super hard to come by these days. And I've interviewed a few in the past, 3-4 months. And obviously I'm gonna have to go with a lawyer that's not superb, but I mean, a lot of them aren't taking cases and whatnot, but yeah, it would take at least a month. And I mean, I also would request that they put forth the 60 days. I believe if it's within 30, it's basically like an emergency thing. Like saying the kids aren't safe and my kids are safe.
All right. Thank you, Mr.
Right.
Mr. Hitchcock. Mr. Zandy, go ahead. Yeah.
And here's the quick response to that. This is a case, and again, it's set forth in my client's declaration. It's set forth in the information from the school in which offered her the job opportunity at Southern Utah that states they want to know, and they want her there by August 16th. So time is certainly of the essence. This is a case, again, in which Mr. Hitchcock has done very, very little since last August in getting his mental health evaluation. You're certainly aware after reviewing the pleadings as to what the issues are now with reconnecting families and his visitation being terminated by Miss Fellows. I mean, there's just a litany of problems, and basically my client's life has been on hold, waiting for Mr. Hitchcock to comply and do what the court very specifically told him to do over a year ago. I believe that order was entered on August 2nd, and here we are now on August 8th, and we still don't have any information from the mental health provider. Now, we still don't have any real information as far as the plan moving forward, all because we've been essentially on hold for 12 months while Mr. Hitchcock has dilly-dallied in doing what was required of him, and certainly my client believes that was by design. Things have certainly not gotten any better with him. We have the same concerns today that we had this time last year. And again, there's no assurances of where we're at. My client is essentially, because of that intransigence, held hostage in Cowlitz County when she tells you, I've got a job opportunity, I've got another life to explore, the same one that they had initially discussed upon separating. Now, my client made it well known. The only way really for me to financially thrive would be to go back to Utah, where she has a significant amount of resources, and that's been contemplated from the beginning. So the request to set this over an additional month, again, I don't think is in good faith. If you look back at the prior issues last spring of 2022, you'll see that this again is kind of a common ploy for Mr. Hitchcock. Request a continuance, request another one, not provide the materials timely, not comply with the mental health evaluation that is over 12 months old now. And here we are. My client has an opportunity. She needs to know right away. We filed this motion. We gave him notice within a day or two of my office finding out, within a day or 2 or 3 of my client finding out that she'd been accepted for this opportunity. And again, it's a benefit to her. It's certainly a benefit to the kids. We're asking to move forward today. If we set this out a month, it's a moot point, because the job, by all intents and purposes, is probably gone at that point. They'll go with another candidate.
Okay, so my understanding, and Mr. Zandy, if you want to weigh in, it's been a while. It's been a while since I've done a relocation, but my understanding is that a relocation request, if there's an objection, if there's a reason for the court to believe that on a final hearing that it wouldn't be approved, if no notice was given, and I shouldn't say that there was an objection, but if there was no notice, if there was no agreement or notice given, and the court finds that it wouldn't likely be approved upon final order, those are the only grounds, and that it's not in the children's best interest. Those are the grounds for the court to deny a relocation. Are there any, and your client is indicating that there's family located where she would be relocating to. She has a job opportunity there, a home that she'd be able to live in currently that would fit all the children in the home as well. All that's correct, right?
It's correct. And just to take that a step further, the statute gives you 11 factors to consider in a relocation. The presumption is that the primary custodian gets to move, provided there is a benefit to either the relocating party or the children, not both. There only has to be a showing of a benefit to either of those. The 11 competing factors for the court to consider is no more weight is given one more than the other. It's basically just kind of a test and a weighing test of all those 11 factors to see how that pans out. There's the emotional attachment of the children to the non-custodian. There's the likelihood of the non-custodian and his or her ability to move closer to the kids. There's a whole bunch of factors that go into that. Disrupting the primary caretaker's relationship is beyond that of overcoming of that as opposed to the non-parental custodian. There's various factors that go into that. And then ultimately the court weighs those against the presumption, which is weighted heavily in the favor of the relocating parent, that as long as there's a benefit to him or her or the children, that relocation is permitted. And then I think you're absolutely right. The court can assess whether the likelihood of the move is more likely than not to be approved at a final hearing. And everything you kind of flows from there. So I think you start with that presumption. You have the 11 weighing factors, and then you have ultimately, basically, what's the likelihood that at a final hearing or trial, this move would be granted.
Ms. Height, you've been involved in this case for quite some time, and you are present. Any comments? No obligation, but if there's anything that you wanted to weigh in, I'm happy to hear it.
Thank you, Your Honor. I have been involved. I am, of course, currently discharged from the case, but have been in some contact with the parties since that time. I would tell the court my concerns that were present when I wrote my report now about a year ago remain. I don't believe that they have been mitigated at all. And as far as a move or not move on behalf of the kids, I would say that currently their visits are FaceTime only. And that would not be really impacted heavily or maybe at all depending on where the kids are residing. So I don't see visitation being impacted at this point.
All right. Thank you, Ms. Height. All right. And just Mr. Hitchcock, and I think you may have cited this, I don't know, in your, because Odyssey is stuck again for me. So I am not on your motion, your objection motion, and you may have cited 2609520. That's the RCW that Mr. Zandy was referring to with the 11 factors. Any additional argument or information you want to give me at this point?
Yeah. Megan has previously, and I've filed this with the court previously, but that she said she wanted to go to Utah to keep me away from the kids. So I argue that it's in bad faith that she's going there. Mr. Zandy argued that she has a job there. That job is $36,000 a year, which is well under what she can make. I mean, she can make that if I did the math for 40 hours a week. I mean, that's 17 and change an hour. You know, I mean, she could get a job. I mean, any of the multiple jobs that I'm a nurse, but I have multiple friends that are entry-level jobs, and many of them make $25, $30 an hour here. So $36,000 a year isn't really a job to move for. Mr. Zandy stated that he notified me the day after the move. This is the only motion in the past year plus that he has not emailed me. He just sent it. He sent it in the mail the day. Well, he postmarked it on the 18th. That was when the bridge was closed. So I mostly wasn't staying at my primary residence because I was working in Longview. And then I went to Utah for a week. So I came back from Utah. This was just a week ago when I found the mailed motion that was not emailed to me. And there's other things as well. Mr. Zandy talks about the mental health thing. It was always a year wait for the mental health evaluation. The really complicated part is that, like, I asked Mr. Zandy, and you have the information on that I submitted, but I asked Mr. Zandy if there's any place that I could do it sooner, and he didn't reply to that request. But later I found out.
I'm going to object to anything that's well outside the scope of the declarations, unless this is part of the material that he submitted that I didn't get. But this is all conjecture and well outside the scope.
It's part of what you got yesterday, Mr. Zandy.
All right, go ahead, Mr. Hitchcock.
And I did email and I did ask him if there was any other places that I could get a mental health evaluation earlier. And what's wild is that I just found out in March that there was another person in Vancouver that could have been done earlier. And from my initial, it actually looks like Mr. Zandy has used this person in the past. So the fact that he didn't tell me about him, he's blaming me for making this last a long time, but he never told me. And I asked multiple people that didn't know about this guy. It's a bottleneck process. And if anyone should understand the bottleneck, it's Mr. Zandy, who's a divorce lawyer who works with these people. And I will say as well, the visits. Oh, as two more things. One, Megan hasn't paid any of the bills on the house. She's been there a year and a half. So she says, "Oh, you can take over the house," but she's leaving me with, over $5,000, $6,000 worth of bills. I mean, she's not just leaving; she's escaping these bills, so she can go live with her parents where there are no bills, and she can, eat their food and have their electricity. And it's not that big of a house. The basement's less than 1,200 square feet.
Want any response to that?
Are you done, Mr. Hitchcock?
Yes, for now.
Okay.
Thank you.
Sure. Thank you. Mr. Zandy, go ahead.
Well, and I was going to argue this from the beginning, Judge. That's why I'll work backwards. I'm going to start with the good. And the good is my client, as Mr. Hitchcock has wanted from day one, has the opportunity to get a job. She's been offered that job at Southern Utah as a tutoring coordinator. That's a good thing. In addition to the pay, and I don't know if the court had the opportunity to look at the benefit package. That benefit package is exceptional. That's retirement, that's medical, that's everything that goes with that. And there's also, again, room for growth and advancement. That's very positive. The other positive of this is my client details for you throughout her declaration, there is extended family in the area. This is extended family that is closely bonded to the children. The children have spent ample time with them at holidays. My client details for you that her parents routinely come up and visit the kids. This is a very strong, well-connected family. This is an area in Utah And I think it was, I don't want to misquote or misstate that, Cedar Springs, I believe. Cedar City. Nonetheless, this is a place where kids have aunts, uncles, grandparents, cousins, and the like, in which they can, again, pick up right where without missing a beat. And that's certainly a positive thing. This, as my client details for you, was contemplated from the beginning. Doesn't sound like that's been objected to by Mr. Hitchcock. Sounds like he agrees with that. This was never intended to keep the kids from Mr. Hitchcock. I don't know where that comes from. This is where my client's from. They came back up to the Longview area because nurses, which is Mr. Hitchcock, make more money. It sounds like he's agreeing to that. And as he states, yes, cost of living in Utah is significantly lower than it is in Washington State, and $36,000 a year in Utah goes a lot further than it does in Cowlitz County. That's the reality. My client is not a nurse. Again, I would object to whomever it is that's telling Mr. Hitchcock that he or she could make more money. It is what it is. Reality is this is a very good opportunity for not only my client, but the kids alike. Let's look at the benefits to the kids. And again, this is one of the 11 factors that is contemplated in the RCW. If you look presently at the kids' ages, this represents as a very opportune time to transition. And we've got one child who just started at St. Helens and finished the year there. That is Luke. Luke, and my client details personality traits, the things he likes and the things he enjoys. Finished up at St. Helens, and now if the court allows the move, would be going to, and I don't want to butcher the name, Parowan, I believe is the name of this school. We provided you information that shows this is one of the best schools in Utah. This is a school that's recognized nationally, and this is a school that rates out significantly higher than St. Helens Elementary does. My client gives you information about the other two children, about the Head Start plan, about how Maury, who just turned 3 years old, is already doing a lot of these learning type functions and activities, that she was in the Read and Grow program, and that the Head Start program that my client anticipates putting the kids in for some kind of preschool type education and benefit to that as a springboard to school at, again, Parowan, again, is very positive and a good move for these kids. The kids have the ability to be around family who they love and who are bonded to. The kids have the opportunity to have, as Ms. Height stated, the exact same contacts with Mr. Hitchcock that they've had over the past several months, again, due to Dad's self-sabotage type methods as it pertains to supervised visitation and not getting mental health evaluations. I think it speaks volumes that he blames me. And again, this is exactly what he's done from the beginning. It's always someone else's fault. I'm lying, the GAL is lying, his past attorneys told him to lie. My client is lying. It's everybody else's fault but his own. To suggest that I should have told him or given him names of institutions in Vancouver seems ridiculous. It also fits this concern that my clients had that was validated through Ms. Bellows' recent visitation notes, that there's this sense of paranoia. How I can advise someone who's not my client where to seek a mental health evaluation seems misplaced at best, if not completely ludicrous. To suggest that he was in this when he's had two attorneys and one was, both of them were competent, one was very good, to suggest that he had no idea where to go or what to do and then somehow blame me or my office, again, is exceptionally misplaced to the point of illogical and lacks complete reason. We are still sitting here 12 months later. Dr. Maherg, who I understand was not contacted until roughly 8 months after the court appointed him, or excuse me, after the court ordered the evaluation, that's concerning. What was Mr. Hitchcock doing in those 8 months outside of making excuses and doing a lot of the same behaviors, if not magnified, that he was doing at the onset of this case? That's a concern. We look now kind of at the negative aspect of this. And again, the file is complete with instances of grave concern. I have not had too many cases in which someone who is ordered to go to professionally supervised visits ends up getting those terminated because of his or her repeated actions the way that Mr. Hitchcock did. If you look at the information from Ms. Fellows, it's not necessarily his interactions with the kids, although there were some cited in those notes. It's basically this hair trigger explosion and this rage, I believe was the word she used, that is right underlying the surface of Mr. Hitchcock's personality. I think it's interesting that we get those notes, we get that termination from Reconnecting Families. We're in court a couple of weeks later to renew the restraining order. That gets renewed. Mr. Hitchcock again presents in the same type of paranoid manner and placing blame on everyone but himself that he continues to do. Court issues that, orders another protection order and limits contact. And what does he do? Within a day, he sends my client a vague message. And this, again, is beyond me, saying you should take the kids to Utah for a week or two. No further explanation. You could read that one of 100 different ways. To me, that is odd given the timing and given the history of this case. That certainly can be construed to my client as a veiled threat. There's really no follow-up on that other than, why are you asking me to do that? And he says, well, I don't have visits anymore. You might as well do that. The context of that is bizarre. The context of the fact of having the supervised visits at Reconnecting Families pulled and terminated, again, that's bizarre. We're going through this case and he insists on phone calls being recorded. He insists on making threats to visitation staff. He insists on speaking in demeaning terms, all because he's got this conspiracy that I'm lying, that the court is against him, that my client is lying, and everybody's believing these. Meanwhile, we've gone 12 months without any information. Interesting, I sent him an email a month ago, and I provided that to you saying, and it was friendly, it was to the point, it was, have you gotten any ETAs on the evaluation from Dr. Maher? I would like to resolve this case. I know my client would like to resolve this case. And what do I get in response to that? Absolutely nothing. So here we are. And now we get a lot of the same recycled verbiage of it's everybody's fault but my own. My client has a desire to move on. She should have a right to move on. She should be enabled to move on. And right now, that right and that ability to do that is to move to Utah so she can pursue her own career. The same career she put on hold so that she could follow Mr. Hitchcock to Longview because nurses made more money here than they did in Utah. That's the reality. And in true domestic violence form, he tries to cut that off. He's now using the courts to do that. This is the same individual who filed repeat motions back in the spring that the court denied and told him to quit doing that. This is the same person who's now using the court system as a means to control his wife and control his kids. And this is the same individual who, throughout the course of 12, almost 13 months, has refused to do anything that he's supposed to do that was ordered by the court last year. So again, if you put that in the totality and the context of where we are today, my client should be able to relocate. She has a great opportunity to provide for herself and these kids. The same opportunity Mr. Hitchcock initially complained of is now there. It's enabling my client to make money, to pursue her passion in a field where she is more than equipped to do so. In a field where she has wages, she has income, she has benefits, and she also has the ability under this contract to stay with the kids for at least one full month during the course of the summer. That's in addition to her other days off and the other benefits that she gets under that employment package. That will save on daycare costs. She has the ability to live with her folks for the time being in a spacious, whether it's 1,200 square feet or not, spacious basement, in which she could rely on them to help her exchange the kids, to help kind of offset some of the burden that's going to be on her being full-time employed and a full-time mom to 3 active kids, all under the age of 7. She's going to have these benefits of having a piece of bare property, again, which is close to her university, in which she hopefully will be employed at here very soon. She can build upon that. And exactly as he says, it's Utah. So she'll be able to do that for cheaper than she would to build up here based on just the incomes, because there's much more to it than just the income alone. My client tells you she's been a part-time grant writer since she's been up here. She's done that for the YMCA. She's done that for various nonprofits. It never really produced a lot of money. That was never the intent, because the intent of the parties was Mr. was going to be the breadwinner. She was going to take care of the kids, put her career goals on hold. She's now in a position through this opportunity to pursue those career goals, to do something that's been on hold for several years while she's been married to Mr. Hitchcock and in Cowles County. That's the reality of where we're at. Again, the presumption is very strong. The presumption is that she can move based on a benefit to her or the kids. And Mr. Hitchcock cannot, under these circumstances, overcome one of those 11 factors, let alone the majority of those factors as the law requires, which would enable him to somehow prevent or block this relocation. My client's in that position. This is good for the kids. We're asking you grant that. Secondary to that is this tax issue. Again, this is one where my client details for you, and we've been back and forth again on this for some time. We're asking the court to issue ruling on the income tax filing for the years 2020, 2021, and 2022. The thing that was not contemplated by the court at the time of the original temporary order hearing was the fact that we got some kind of adoption support, which does muddy the waters a little bit. My client has run the figures, and it's essentially a benefit to the community. And that's Mr. Hitchcock and my client if they claim married and file a joint return for those tax years. And again, I think that's a reasonable request. And again, one that I made to Mr. Hitchcock back in March, going so far as to send a proposed order, which we heard crickets. He reaches out and contacts when he wants us, when he wants to be heard. Otherwise, we don't get anything from him. And again, to suggest that I should point him in the direction of a mental health evaluator is borderline ludicrous. That's where we're at. That's the request. It does not impact his visitation with the kids whatsoever. And given that we have literally been spinning our wheels in the hamster cycle for the better part of the last 13 months, it's time to get off that. And this is my client's opportunity to do so.
Your Honor.
All right. Thank you, Mr. Zandy.
That was a long ordeal. Can I speak?
Briefly.
Yes, I would like to do briefly. my main things is like, once again, like Megan has about $6,000 worth of debt from the house that she's living in that she hasn't paid. My second main thing is that this is not an emergency relocation. This should have been like a, your typical 60 days out. This is not an emergency. It was sprung very quickly. That's not the way these moves are supposed to work.
Mr. Hitchcock, do you have an appointment with for a mental health evaluation?
Yes, I've done the mental health evaluation. There's been some issues, and that's yes. So it's still getting worked out, but yes.
Okay, so it's done. We just don't have the report back.
Basically, yeah.
Okay.
And I don't know if the report's finished. Yeah. Again, this is not how these are supposed to go. Is within 60 days as well. I mean, Megan's ducking out of I was paying her Chase account just because it was coming out of my account until I had to close the Key Bank account down. I didn't know what to do about the mortgage because that was one I just kept paying because felt like it had to be paid. And she didn't take that over until just April of this last year. So money wise, and then they're asking to have more of my tax return from last year. I don't feel like that's fair. And I don't, again, this move is I want to move in 3 weeks. Let me move in 3 weeks. And once again, that's not the way this works. It's supposed to be 60 days notice. And there's examples of when it's not 60 days. And this does not fall under any of those. And Mr. Dandy tries to make me look pretty bad. And, I don't know how well that works, but it's not, everything he says isn't accurate. Everything I say probably isn't 100% accurate, but I try to be accurate. I want you to know that. And I do speak the truth.
All right. I appreciate that. Thank you. So I think Mr. Zandy addressed in his response the reason for the shorter notice in this case. I understand Mr. Hitchcock's position that didn't provide him a lot of opportunity to respond to the move, and I understand. So I understand both parties' position. We have been kind of in a stalemate for quite some time in this case. I do note that with the most recent restraining order, there is a limitation on, so visitations are by way of Zoom at this point, or excuse me, FaceTime or some other.
I have supervised visits, but Beth did cancel those. I immediately found another institution and they sent Megan the paperwork, and I asked her multiple times to fill out that paperwork so I could have the visits, and she has not done that. And that's why I said, go to Utah. She said, why? I said, well, it could be good for a number of reasons, and I would appreciate it if you filled out that paperwork. I don't know if you had the chance to review my, what the kids, what the notes, the visit notes said, but my kids and I relationship is pretty amazing and wonderful. And they continuously asked, to come to my house, to if I can come over. These things where they're being denied access to me. And again, I argue this is in bad faith, and I can get you even today that information where it says that Megan was trying to keep them away from me. Well,
I appreciate all that, Mr. Hitchcock, and I do note that a lot of these visitation notes are very good. I'm not sitting here in judgment of you as a person or you as a father. I do understand some of the concerns that the other side has brought up. Frankly, this case isn't over. So to think that Ms. Hitchcock is the sole decision maker on your access to the children is incorrect. So because that hasn't been ultimately decided yet. Before me today, and I did also note in your objection to relocation, you touched base on the taxes and your concerns with that.
Again, the 6,000.
I let you talk without interrupting you, Mr. Hitchcock. So I appreciate the same. Assuming the numbers are correct, and it would be a benefit to all the parties to file jointly for 2020, 2021, and 2022, I'll authorize that. I'm going to authorize the move, but I also on a temporary basis. So I think it needs to be some additional information exchanged. I also, at this point, with visitations via FaceTime or whatever, those shall continue with Mr. Hitchcock. Additionally,
I have a couple of requests.
there's a request for, I know that Mr. Hitchcock indicated that he requested that visitations be set up through the agency in Vancouver. That hasn't been done. With the start date of this new position a little over a week away, I'm assuming that won't happen before. However, what I would like to, I'd like to have, if at all possible, the children have an opportunity to have a supervised visit with dad before they leave. And if the agency in Vancouver is where it needs to be, then I'm assuming Mr. Hitchcock will try to get that set up and work with Mr. Zandy to get that set up. The kids should be able to see dad before they leave. And I know that's a quick turnaround time, but frankly, the ask came in a kind of an expedited manner. And so I'm going to order that occur. If there is some, I guess, Mr. Zandy, I want that to happen no matter what. And if that means there's a request that somebody else supervise that both parties agree on for a last visit, that, you know, that I want a visit to happen. And then he still has, there's nothing that stops supervised visitation moving forward. So if he requests that, then
I do request that. There is one in Cedar City I've looked up.
So if he comes to Utah and wants to visit the kids, then she has to help facilitate and make that happen. All right.
Essentially keep the orders as is.
Yes.
Correct. And then just make sure that we get between now and the 15th, some kind of we'll work hard to try to accommodate that too.
She said, do it no matter what, Mr. Zandy.
Like I just said, work very hard to accommodate that as well.
All right. And as far as the money and the house and the transfer of the house, I don't know, Mr. Zandy, there's obviously Mr. Hitchcock has concerns about some outstanding debt on the house. I don't know if, and that wasn't addressed in your response, probably given his late objection. I don't know if you want to set this for a review in a couple weeks to discuss that matter, or
I'd rather not. I'm hopeful that a couple of ways. If he wants to have the house effective after my client moves out, which would be on the 16th, that's fine. My suggestion would be we reserve any issues related to that. My client does have a response to that. I don't think what you've been provided necessarily accurately reflects what's truly happened in this. Nonetheless, we should reserve that, put it on a balance sheet when this case is all over and resolved. In the meantime, he can make the payments on the mortgage moving forward, and we can go from there. If he either wants to bring it back, if I'm incorrect, then certainly they can do that. But for now, with as many times as we've been in court over the past year and a half, I just assume try to keep the costs and the appearances down as much as possible.
All right.
I would ask that she pay that before she goes, the taxes.
Well, my hope is that since she's been living there, she's been making the payments without any additional information before me. I'm not. All you did is say that she hasn't paid. I don't have anything that shows me.
It's in there. I attached it. There's like $5,500 due just in taxes. It's
the existing order states she's to pay the mortgage and that he's to pay the taxes, and the insurance is the best of my recollection. Again, I can confirm that, but she's been paying the mortgage.
I know exactly what the order says.
That's an issue that we're probably going to have to circle back to on a balance sheet when this is all said and done.
Your Honor, the order doesn't say that. I can tell you exactly what it says if you'd like.
Which order are we operating under?
He's talking about a previous order that
I understand that. When was it entered?
January 4th, 2022, I believe.
I was to pay the mortgage through June. Mortgage and taxes through June. I ended up having to pay the mortgage through March of this year, April of this year.
January 4th, 2022?
I believe so. I believe it was the initial order from
it was 2021.
Back when Mr. Hitchcock was represented by Ms. Baldwin. I believe Judge Hahn entered that order back
20 of 21. 2021. Sorry. 21st.
Maybe it does make sense that we just reserve on that so my client can respond. And I would suggest we set this out 3 weeks for presentation. And if there's any issues on the house, we can take it up then.
Your Honor, if she leaves, she's never going to pay it.
January 18th, 2022 from the hearing on the 4th.
Yes, I see it. I am looking at it now. So the mortgage is petitioner. And petitioner pay home mortgage through June 2022. Thereafter, respondent pay home mortgage is what this order indicates.
And it was clarified in July of that year. But I mean, once again, it was just through June. And once again, I ended up paying the mortgage through April of this year.
Okay. Well, let's, so if we are setting presentation for the 29th, let's review the issue of any outstanding payments or debt on the home on the 29th, 1 o'clock.
Fair enough.
So meantime, everything other than the move is approved. Everything else is status quo. And either party, if you want to file supplemental information regarding any debt on the home, taxes due, feel free to do so.
Your Honor, one more question.
Sure.
Megan has lived in the house. We've been separated almost 3 years. She's had primary use of the house that time. If, you know, I take it over, then I if I fix it up, I mean, I would ask that the order would be that I would get to live in it for a year, that I would get to utilize it for a year. Just because, you know, Mr. Zanny could come along in 2 months and try to force the sale of the house. If she's giving me the house to take over, I would ask to have it for 6, 8, 10, 12 months so that I can actually have the house, not just fix it and have it get sold. Which obviously we're going to sell it, or I buy her out, but I would ask for some time with that. Okay.
If that's your request, then make sure that you remind me of that when we are discussing it on the 29th.
That's right.
All right. We're on for pretrial. All right. Oh, we're just on for pretrial.
No, we're on for a motion for contempt.
I don't have a contempt. I have pretrial management.
Oh, I thought we were on the motion for contempt. Is that next week then?
I have a show cause contempt for 8:15.
Oh.
If you all
had known that, I would have just asked us to move that one to the other.
Well,
I got them backwards.
Are you, Mr. Roberts, did you think we were on for contempt as well?
No, I thought we were on for contempt next week.
Okay.
And I think you told me that, and I think I had them backwards in my mind.
I feel awful making you guys wait this long. Then
I should have piped up, and I apologize too. I was just letting the court go in the order, and I didn't know if Ms. Winkles had somewhere else to be. So I'm sorry to both of you.
Oh,
no, it's we're all sorry. Well, as far as pretrial, since we'll be here next week, any issues, discovery issues, both parties ready to proceed at this point with readiness that I show is next. I have readiness on the 22nd and trial slated the week of the 28th of this month.
And I'm fine with that. I mean, I didn't get everything I wanted in the last discovery, but I think just setting this, getting this on for a trial, I think just having testimony will get everything out anyway. I don't think there's any documents that I'm missing per se. So I'm ready. I think we've even done an ER-904 already.
Mr. Roberts?
I think that's fine. I came on the case fairly late, but I think given the circumstances that testimony and what happens between now and then should get us where we need to go. So with that said, we can move to the next date and see you next week.
Okay. Well, I again apologize for keeping you here for 2 hours on a pretrial, but I will see you next week, and I'll do my best to call you at the beginning of the docket.
Thank you, Your Honor.
All right. Thank you. Have a good afternoon.
You too.